I have Logan's on the way.
Oh my god, very
He's
exciting.
slightly late. I don't know if you heard me, Sammy.
Yes, I heard you.
See... Okay.
Perfect. DLC is not being here, so I am going to search it everybody.
Okay.
Put your hands up.
Yep, put your hands up.
Yeah, search the cops for.
You're not gonna like it.
You better not have any drugs.
I'm curious to
I'm
see
just
what
kidding.
their pockets look like.
It's pretty bad.
I am not doing this.
Hers are fucking terrible.
Wait, didn't you have red hair earlier?
Can I cut the line so I can go sit down and not have to stand on my broken leg? Behind her, she's also got a broken leg. Can we both cut the line?
Yeah.
There's a line? I thought this was just the...
Listen, until the corrections, Logan getting here, you are in charge of searching the people. You can start with me.
They're on the way.
Okay.
Oh, they're on the way?
They said they're slightly late.
Do you want us to still search or wait until they get here?
The Sunny, I would assume. Ma'am, quick question.
Yeah?
But what are you doing with these guinea pigs?
Oh, they are my pets.
You have guinea pigs? I have a ferret at home.
You just bringing them in there?
Yeah, they come to the car. They help determine the ruling.
I have a ferret at
I
home. His
put
name is Noodle.
two pictures on the floor. One they say guilty, one they say not guilty. And then I let the guinea pigs go. And whichever way they go to, that is the ruling.
That makes sense to me. Alright, go ahead.
Thank you. Maybe just let the broken leg people in, and maybe the broken leg person attorney, and then everybody else can wait for corrections.
Okay, sounds good. You already searched her. I'll search.
Yeah. All right, ladies and gentlemen.
Thank you.
I am going to eat. But I am waiting here. Ah, yes. No problem. You're spicy. I did not tell him to let you in.
I let myself in. I did let... He searched me and let me in. Do you have a gavel?
Yeah.
Is that where Holmes is just gonna hide for the trial? Is behind the bench?
Yes.
Okay.
Maybe. But I like to move around a lot, so I must step it on him.
You have to pay money for that.
At that point, he deserves it if that's where he's sitting. If you're gonna sit back there, you're gonna get stepped on. That's how it's gonna work. You deserve it. You chose it.
She's not wearing high heels. It's okay.
Aww.
The first I see Your
I
Honor.
was heard that would make me want to go and change.
Your Honors?
Yes?
The defendant has 15 full cans of gasoline on him that he doesn't have anywhere to put.
I don't know to tell you. I am not allowing the petrol cans in the courtroom.
Oh, okay, we'll figure it out.
Aww.
Why does he have so much gas?
I was trying to be a safety car at a race and like fill them up, but then nobody joined my race.
It's not a NASCAR. We have to do pit stops, okay?
Alexa, turn my bedroom to white. Copy that. Aw, hey, teddy bear.
Can he, Miss Lawyer? Can he borrow your car to store them for a minute? Oh.
Yes, my baby. We are resting so peacefully until somebody came. I waited so patiently for you. Oh, you want to play? So sad. Oh, I'm sorry, Daddy. You can't play right now. My poor dog has a terrible past few days. First, he got shaved, got all his fur cut off. And then, yes, and then he got neutered today. And now he is wearing a cone. Oh, I need to,
Thank you, Your Majesty.
oops. Oh my god. I am the royalty.
Your Honor, are we allowed to let everyone other than the injured and lawyers in?
Mm. Yes, that is fine.
DUC is on duty right now if you want to wait.
How are you, Your Honor?
Excuse me, sir. Are you attempt to ex parte?
It wouldn't be ex parte because all I asked was how you were, not anything
I know.
pertaining to the case.
Are you already trying to butter up the judge? What is happening here?
I was just asking how Her Honor was doing.
He's having
Yes.
a party.
Defense attorney need equal opportunity for the buttering. It is your turn.
I mean, oh, well, see, if I'm going to do that, I'm gonna tell you how lovely your hair looks. I love the buttons.
Oh my god, thank you. They are my signature.
That's,
what-
that's how you
What
do
about the thing behind on her neck?
I have a rebuttal to her rebuttal.
It was not a rebuttal, but please proceed.
I enjoyed your song that you sang for all of us outside of the courthouse earlier.
Oh, I missed the song?
Yes,
miss
you
the
did.
song.
Sad days.
It was very, very good song.
I am sure it was.
Maybe
Oh my
after this
gosh,
is
the
over,
corrections,
Her Honor
thank
can
you.
sing it for us.
Oh, I need to go to the back
Hi,
so he
Logan.
can announce me and say,
Oh,
all right,
alright.
so you
Oh.
all have to stand up.
In Your Honor. All right.
I'm going to sit so I have the illusion of having this thing up.
Exactly, thank you.
You're welcome. Very briefly.
Sorry about not notification. Thank you for being able
No,
to
you're
show
okay.
up at the last minute. How much time do I have?
A minute.
Oh my gosh.
Oh, let me go and tell them to turn their phone off. Hold on. Ladies and gentlemen, this is a reminder to silence your phones to ensure that they will not ring or vibrate loudly during the proceedings. Please remain respectful throughout court and do not disturb the proceedings. Please consider this your official warning.
Oh my god, thank you.
You're welcome.
I'm just doing some organizing right quick.
You're all good.
Almost done. I like to have the evidence at hand so I don't have to look upon the docket. Let me see. Exhibit A, Exhibit B, Exhibit C, Exhibit D. Perfect. I hate how these links are in bed. It is so annoying.
You're shouting.
Am I shouting? Alright, I am prepared.
All right. All rise. Court is now in session with Honorable Judge Sunny D. Hillard presiding.
Oh my gosh. Hello there. Let me see. Making sure we are all here for the correct proceeding. 2026, CM 099, Seat of San Andreas, Dorsey's Chess, Whip. Is this correct?
Your Honor, that is correct.
Oh my god, perfect. Announcing of the parties for the state.
Val Anderson, Senior Prosecutor for the state, Your Honor.
And defense.
Corina Ivanova, in lieu of PDO, managing partner for Ivanova Law Services.
Wonderful. And defendant. Get perfect. And are you being okay since your trip to the hospital, defendant?
I'm not as good as I was earlier.
Are you being okay to proceed?
Yeah, I mean, I'm here. I've got some water.
Listen, you may all be seated, by the way, unless you're the attorney. I guess you could also sit if you are the attorney. Maybe the bailiff should not sit. I don't know. Maybe if your legs get tired, though. Anyways, let me see. The charges today, state.
The charges before the court today are 1 times aggravated battery and 1 times destruction of property, or aggravated destruction of property.
Perfect. Oh no. Oh. Wonderful. Let me see. Pretrial motions. The court will not. Judiciary Clarkson be unavailable for court, and I am taking over. If you're objecting to me take it over, I don't know what to tell you because I am here. Do anybody object to me take it over this court?
State has no objections, Your Honor.
Deviance has no objections either, Your Honor.
Okay, perfect. Any pretrial motions from the parties?
I would yes, like to have the lesser offenses of vandalism and battery without the aggravated circumstances on the table. I understand that the battery one may be a fight, but I would like the lesser included charge of vandalism on the table, please.
State your objection to the lesser included offense, vandalism, and battery for the consideration of the court.
Could I have one moment, Your Honor?
You may have one moment. There should not be. I don't know why they would object. They would make their court easier. Let me see right quick. This one. Hmm.
Your Honor, just for clarification, the defense is looking to add in for consideration the lesser charge of vandalism and not completely get rid of the destruction of property charge, correct?
That is correct, Your Honor. I'm asking that vandalism be the lesser included, not completely drop the other and replace it.
So the state will have no objection to adding that for consideration from the court. However, we will stand firm on the aggravated battery, as the battery itself was done against an on-duty member of law enforcement who was in uniform at the time.
I have no rebuttal for the aggravated circumstances.
Perfect. Any further pretrial motions? The court will be adding those lesser included charges for the record to the consideration during this proceeding. Any further pretrial motions?
Your Honor, I do believe that the evidence put forward by the state on Monday was not ruled on by Chief Justice Clarkson, and I did not see any objections from defense in regards to it, so I just wanted to confirm that that was accepted as evidence.
I thought she ruled on that.
Did she rule on that?
I am not seeing any ruling on it unless it was done in the separate email. Is there being any objections to any exhibits present upon the docket?
No objections from me, Your Honor. I believe all of the evidence that was submitted was the same that was in the
initial
fact
indictment.
record.
Perfect.
And for just simplicity's sake, it is going to be line 19, Your Honor, if you needed that.
Thank you, Mr. Henderson. I already have.
Okay.
Thank you, Mr. Henderson. I already have. 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 Thank you, Mr. Also, I did, for the record, note that it was not relied upon. Perfect. The court will be accept all of the evidence for the consideration during the trial. You will still have to, of course, lay the foundations for the evidence as usual. Finally, any further pretrial motions?
Nothing from the state, Your Honor.
Nothing further from the defense.
Wonderful. The bailiff here they assert a lot of court rules, so I don't think it's necessary to be reiterate anymore. Are you wish to both have opening statements?
The state is willing to waive opening statements.
Defense will also waive opening statements for the sake of time.
Perfect. Wonderful. State, the floor is being yours then.
Okay. Your Honor, the state would like to call as its first witness Officer Hayes Grant.
Mr. Grant, are you being in the court?
I'm trying.
It appears he is experiencing what the youth call a skill issue in attempting to reach the witness seat.
Mr. Grant, you cannot be testified from back there. Please proceed to the witness stand.
Which chair am I going to?
That one over there. Mr. Grant, please raise your hand. Would you like an oath or affirmation? Would you like an oath or an affirmation?
Oath.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All sworn in, Your Honor.
Your Honor, permission to approach the lectern?
Yes, you may be approached the lectern.
Hello there, Mr. Grant.
Hello.
Could you, for the record, state your name, rank, and occupation?
My name is Hayes Grant. I am a officer for the SASP. My badge number is 513.
Thank you. Could you please explain to the court how you came to be involved with this case?
Myself and 411 Rachel Bishop responded to a 311 call about something happening at the courthouse. Upon arrival, we found the back patio of the courthouse in a disarray state. There were tiles that had been painted over. Coal was found in the planters. There was glue on the railings. There were a couple other things that I can't remember immediately off the top of my head, as well as a hauler truck parked on the back patio, not in a parking spot.
Okay. What did you do with the vehicle that you found on scene?
The vehicle was left as is for the moment as we investigated, but was eventually impounded.
Okay. When you impounded the vehicle, did you do any checks in relation to that vehicle on scene?
Yes, I checked the VIN, the glove box, the trunk, and its license plate.
Did the vehicle come back to anybody?
It seemed to have been a rented vehicle.
Okay. Your Honor, the state would like to submit exhibits A and B in their entirety for the record.
Defense.
I am so sorry. No objections to the vehicle being entered.
It was A and B.
Yeah, no
Just so you know.
objections to A or B.
Perfect. So I admit. You may be continue.
Will do, Your Honor. After, or what steps were taken to continue your investigation?
After initially looking over the back patio and taking in all of what had happened, I went to step inside of the courthouse and found a puddle of water immediately at the door. After fully entering, I saw the defendant spraying the back part of the back courthouse with the power washer.
Okay.
I tried multiple times to get his attention, to which it seemed he could not hear me because of the headphones he had on. So I walked into his line of sight and tried to get his attention again, in which he then sprayed me. Then ran to the back, sprayed me again, and then ran for the back door.
Okay. Do you see the individual that you were dealing with in this courtroom?
I do, yes.
Can you identify him and where he is at this time?
It is Chase Weep, I believe is how his last name is said, sitting at the defendant's seat.
Yep. Okay. After running out from the room through the door, where what happened?
Myself and 411 decided to try and chase him and told him that he was being detained. Again, which I still don't believe that he was able to properly hear us. He made a run for the truck that was parked on the back patio. I was immediately behind him, and as soon as he sat in the driver's seat, I deployed my taser and arrested him once he was done convulsing.
Okay.
And then proceeded to document both the outside and the inside of the courthouse while 411 sat with him.
Okay. To your knowledge, was the defendant read his rights?
Yes, he was Mirandized by Rachel Bishop.
At the time of his arrest, did the defendant say anything to you?
When he was arrested, I cannot recall. There were some comments when he was being transported to the cells.
What was said by the defendant while you were transporting him to the cells?
I made the comment that he had assaulted me, and in doing so, he responded with, "I didn't do that. I'm pleading not guilty."
Were there any other comments made during transport or in the cells?
Outside of his rights being read and speaking to him about getting a lawyer, I don't believe so.
Oh, okay.
I tried to stop talking to him because I was getting a little bit angry.
That's okay. Part of your job is de-escalation, and it's an appropriate form of action to take. At this
Counsel
time, this
testify.
has no further questions for the witness. However, we would like to also enter into evidence at C in its entirety.
No objections to the evidence being entered.
Wonderful.
Okay.
Going to see if she's going to ask permission. Would you cross-examine? Yes?
Yes, please, Your Honor. Permission
Perfect.
to approach.
Oh, yes, you can be approaching.
Right, hello, Mr. Grant, correct?
Correct.
Awesome. Now, you stated that there was a tile that was painted over. Is that correct?
It looked more like it had been bleached than painted, and I found a bottle of bleach next to it.
Okay. And you also said that he had headphones on at the time that you came in contact with my client.
I believe so, yes.
Okay. Did he, when you first tried to initiate the conversation with him, did he react immediately?
He did not.
Okay. When he finally did react, and of course he has the power washer in his hands, as you said, and he turned around, do you believe that it was intentional that he sprayed you with the water?
I could not say for the first time, but following time, I am positive that it was because he was looking specifically at me.
Okay. And so when he sprayed you with the pressure washer the second time, was there any injury that you had to be treated for?
No, I was thankfully far enough away at that point that it did not cause any injuries.
That is not a good question. It does not require injury.
And with the water, whereabouts was the water found? Other than, I believe you said, the front door. Yes.
On every single wall inside of the courtroom.
Okay. And with the water on the walls, what kind of damage were you looking at?
Depending on how quickly it was cleaned up afterward, I did not do the cleaning myself. I believe Public Works came and did it. I could not say what the extent of the damage was, but if it was left there, it could have easily caused extensive damage to either the wallpaper or the wall itself.
When you brought up Public Works, when were they called?
I did not personally call them, so I could not say.
Okay. No further questions at this time.
Wonderful. Redirect.
One moment, Your Honor.
You may need to repeat that.
One moment, Your Honor.
Perfect. You may have a moment.
Officer Grant.
Yes.
During your collection of the evidence in the what is classified as the lower floor down in the Saba area, did you know any electronics or additional material that could be damaged by water?
If I remember the setup of the room correctly, just below the stand where the podiums are, there are stairs leading down to where there are a number of laptops and or computers. They could have very easily have gotten damaged from the water, as well as computers upstairs where the walls had also been sprayed.
Okay. Thank you. The state has no further questions, Your Honor.
Any redirect? With recross? That is a word.
Yes, yes, Your Honor. I have one simple question. Can you confirm that there were electronics that were damaged?
I cannot confirm whether they were damaged or not.
Thank you. That is all from me.
Wonderful. Any plans to be recalling this witness in a parties?
Not from the state, Your Honor.
Defense?
None from me.
Perfect. Mr. Is it his grant or grant his? I don't know.
His grant.
Mr. Grant, you are dismissed. No honor subpoena any further. You can stick around or you can leave, whatever is making your heart happy.
Okay, thank you, Your Honor.
You're welcome. State you may be presenting the next evidence or witness.
Your Honor, the state would like to call Senior Officer Rachel Bishop to the stand.
Lady Bishop being in the court.
Yes, Your Honor, I am here.
Oh, wonderful. Thank you.
Thank you, thank you, thank you. Sorry, I'm fat too. Do I sit here or stand?
Preference.
No, okay.
Alrighty, alright. Ms. Bishop, could you raise your hand, please?
Yes. Oh. Okay.
Would you like oath or affirmation?
What's the difference?
One you swear to God, one you don't.
Oh, okay. Oh.
Do you swear to tell the truth, the whole truth? Hold on. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
No sworn in, Your Honor.
Wonderful. State, floor, yours.
Thank you, Your Honor. Senior Officer Bishop, could you state your name, rank, and occupation for the record?
Senior Officer Bishop with the San Andreas State Police.
Mm.
How did you come to be at the courthouse on the day in question?
As in today?
No, the day of the incident.
Oh, okay. I'm sorry.
Oh my God.
So there were multiple 311 calls that came in regarding possibly somebody at the courthouse that was maybe confused or something. They were kind of all mumbo jumbo and didn't really make a whole lot of sense. So we came down to investigate and see what was going on. We arrived. We could very loudly hear a power washer.
Okay. What did you observe as you guys made your approach to the courthouse?
There was what looked to be almost like somebody had, just being frank, it looked like somebody had vandalized pretty much everything that they could touch outside of the courthouse. And then we could hear a power washer. We couldn't figure out where it was coming from until we realized that it was coming from inside of the backside of the courthouse. There was, I know my fellow officer named some of the things that were seen out there. I know it's in the record, but there was everything from glue on the hand railings and bleach, and the hedges were ruined, completely cut back, all haphazardly. It was quite literally a mess.
Okay. And when you and your partner made entry into the courthouse, what did you observe inside?
So my fellow officer went in before me. That was when he got sprayed the first time. So I did not witness the first spray. When I came in, was when the suspect was running from my fellow officer, was spraying him over and over, and then proceeded to run out of the courthouse while we were commanding him to stop. Very, very obviously commanding him to stop. We were within his eyesight, so even with his headphones on, he should have known.
Upon no. Once you followed the subject outside, what happened?
He then made a beeline for the truck that was parked outside. It was parked on the concrete, which, I mean, that's, I don't even know if it damaged the concrete or not. We didn't get to look after that, but he tried to climb up into it, and then we had to. I don't remember how we got him out of it. I don't recall, but we, got him out and got him in handcuffs.
Okay. Was the subject read his rights?
Yes, I Mirandized him.
Okay. Did the subject say anything to you upon being Mirandized?
After he had been Mirandized, he did make some comments about how he felt that I don't remember which judge he was referencing, but he was making comments about a judge stating that he had done something to the courthouse and he was trying to make it right. It was kind of confusing to what he was saying. We were explaining to him that, that he had assaulted an officer and all this and everything, and he hadn't even been read his charges yet and was saying he was going to be pleading not guilty without even knowing what his charges were.
I'd like to object to the question and the answer there, Your Honor, based on not admitted in evidence. There's nothing in the statement of facts or otherwise that states that he made any type of spontaneous utterance prior.
Rebuttal.
Give me one moment, Your Honor. Your Honor, the witness is testifying conversation she had with the defendant after having been read Miranda. While it might not be in the initial indictment or statement of facts, people's memories change. Things come back to them as they review information. It is quite possible at the time that was not something that was in the forefront of her mind, but something that she remembered did occur.
If I may, Your Honor.
You may.
Unless I misunderstood what Officer Bishop, or excuse me, Senior Officer Bishop was saying, was that he had said something prior to being Mirandized. If that is the case, then I will withdraw my objection. I don't know if there's a way to get confirmation.
Senior Officer Bishop, for clarification, was this question asked, or was this brought up after or before Miranda?
This was all brought up after he was Mirandized. However, just for the record, we don't often summarize every single detail of conversations within within our MDTs when we are writing everything up afterwards.
Okay,
we can't. There's no way for us to do that.
Okay, okay.
Understood. I will withdraw my objection. I misunderstood. I heard and believed to have heard it as there was a statement made prior to, which if it had been spontaneous utterance, it would likely have needed to be in the report itself. I apologize.
No problem. I am often misunderstood many times.
You and me both, Your Honor.
Yes. Yes, that is what I have on the court record. Question he assert anything after Miranda, and that is where she assert the comments. You may proceed, state.
Were you the officer on scene to search the subject?
Yes, I was.
What did you find on his person at the time?
There was a plethora of tools and things that you would find at a hardware store. I don't recall a lot of the specifics, but I do recall they had a pressure washer refills. I do believe there was some duct tape. There was a ton of, I want to say there was gasoline, but I don't recall all the specifics of how many of each item and things like that.
Your Honor, the state would like to enter into evidence State's Exhibits D in its entirety.
No objections.
Wonderful. So admit.
The state has no further questions at this time, Your Honor.
Wonderful.
Permission to approach.
You may be approaching, yes.
All right. I just have one question. Other than the water, would you say that any of the property was majorly damaged or completely broken beyond repair?
Objection calls for speculation.
The penal code calls for destruction of property to encompass major or total damages. I mean, they do a bit of speculating when they're charging this.
I don't mind answering this.
The state withdraws its objection.
Perfect. Now you may answer the question.
Okay, thank you, Your Honor. Sorry, I don't come to court very often.
Me either.
So, in my experience, if I were to spray with high-powered water electronics that are not meant to have water, in my experience, they usually will either stop working permanently or be extremely damaged. And there were many computers in that back room that got sprayed with water.
I was going to ask, was it documented that there were damaged electronics?
There were photographs taken of the damage, as far as I know.
One moment, Your Honor. I'd like to. I'm getting conflicting statements. So if you don't mind me checking the evidence list quickly.
By all means, please do. Do you need a few seconds or recess?
No, just a few moments.
I haven't looked at any of this evidence yet.
Okay, so as I look through the evidentiary photos, I do not see any photos that document electronics that were damaged. Did you physically see damaged electronics, Officer Bishop?
Senior Officer Bishop, and yes, ma'am.
Okay. All right. Nothing further, Your Honor.
Your Honor, the state has no further questions for the witness.
Wonderful. Any plans to be recalled this witness?
Not from Your Honor.
Defense?
No, nothing further from me or any objection.
Perfect. Let the bishop, you're no longer under subpoena, free to go or stay, whatever is making you happy.
Thank you, Your Honor.
Wonderful. Anything further from the state?
No, Your Honor. We have submitted all the evidence and witness testimony that we intend to admit before the court.
Wonderful. There are some words I am needing to hear. State.
The state rests.
Wonderful. Defense, the floor is being yours.
I appreciate it, Your Honor. I would like to call my client, Mr. Chase Sweet, up to the stand, please.
Okay, wonderful.
Yeah, I'll move Mr. Whip. Can you please raise your hand? Would you like an oath or an affirmation?
You're going to have to speak it
Affirm.
up, mister. Thank you.
Affirmation. Do you solemnly affirm to tell the truth, the whole truth, but nothing but the truth? That's it?
I do.
Okay. Also in your honor.
Wonderful. You may be approached.
Well, Mr. Wimp. So, can you walk me through how you ended up at the courthouse with a pressure washer and various other items on the day in question, please?
So a little bit before that, a couple days, I was at a bail hearing back there, and I was very nervous, and I ended up chewing on the table a little bit, and then the judge pointed out that I got my saliva on the table, and so I licked up the saliva, and that didn't satisfy them. You know, my nervousness eventually got me contempt of court, and I felt really bad about that, and I thought the judge would want me to, you know, pay my, not respects, recompense. I mean, she fined me, but, like, the fine she made less than the original fine. And so I thought I should, like, go clean up back there. And so I printed out some signs, and I got some tools, and I decided to try to make the place beautiful.
Okay, and you say you tried to make the place beautiful. In what ways did you attempt to do this, Mr.
I noticed, you know, one of the tiles had a little bit of like mold on it, and so I scrubbed that and bleached it. A couple of the rails were a little bit shaky. I glued them back down. The hedges, I don't know when the last time they were trimmed. I tried to do it. I'm not a professional hedge trimmer. I got the second one was better than the first one. I fertilized the plants, and then I went inside, and you know there's some very white brick walls in there, and I don't know if any of you guys are familiar with the concept of, you know, white things, but they get dirty fast. And so I pressure washed some of the white bricks in the areas that were, like, you know, free of obstruction. Not the library area, obviously. Books don't like water. And then I was gonna dry it all up with my leaf blower, the leaf blower that, I don't know, the guards can say that I had earlier. And I was gonna dry it up, but I never got the chance.
Okay. All right. So when you first came in contact with the police, they came up to you. Did you have headphones on?
I had not headphones. Well, I had headphones around my neck, but I had ear protection, like earmuffs, like the construction earmuffs on.
Could you hear well your surrounding?
With that and the pressure washer going, no, not really, no, I could not.
So when the officer came up to you and tried to initiate contact, what was your reaction when they finally did get your attention?
I'm a bit of a nervous. Well, I admit that I jumped as I turned towards him, and I was pressure washing at the time, and I didn't release the pressure trigger, so I sprayed him a little bit, I think. I was shocked. I put up signs saying that people weren't supposed to. Yeah.
Okay. Now, later in the interaction, it is stated that you sprayed the officers or officer again. Why did you spray the officer?
So I didn't really process that he was an officer at first. I just saw the gun in his hand. And so we were on kind of like the upper platform area back there. And so I kind of ran towards the back, towards the lower area. And I was like shooting up into the air with my pressure washer a little bit. Are you familiar with squids? And like how squids get away? they threw up some ink to like distract. That was my plan. And then I got behind the cover back there, and I shot up in the air a couple times.
Okay. At any point during the interaction, once you realized that they were police officers, did you have any malice or malintent towards the officers?
Excuse me, Your Honor. Objection. Forgive me, I can't give the exact objection for this, but all this questioning and testimony sounds to the state as if it's an affirmative defense that was not raised on the docket prior to trial.
Rebuttal.
I would argue that it is a simple line of questioning, asking him about the events of the day and his frame of mind. I don't know that this would be an affirmative defense. We're not saying that he is mentally incompetent to understand that they were law enforcement officers or anything of the such.
Your Honor, it sounds to the state as if... Or, apologies, I didn't wait for you to ask for a rebuttal.
I love a rebuttal, Mr. Anderson.
May I continue, Your Honor?
No, I'm just kidding, yes.
Well, that may be the case, according the witness's or the defendant's testimony is justifying, or sounds like it is beginning to justify what could amounts to a self-defense claim as to, I had no idea these were law enforcement officers at first, that is why I did what I did.
If I may, Your Honor.
Last causes, yes, you may.
This was all brought up with the officers. The officers opened the door when they brought up the fact that he flipped around very quickly when they finally did actually get his attention. This is not an attempt to claim self-defense by any means. We are not claiming self-defense here.
Perfect. The court will be overruled this objection. I will take note. Not affirmative defense.
So thank you, Your Honor.
Thank you, Your Honor.
You may be proceeding in a malice toward the officers. No, don't answer my question. I'm just reminding the court where we was being.
So, Mr. Wu, the question was, once you found out that they were in fact law enforcement officers, did you act with malintent or malicious intent?
No, I don't fault them really. They were just doing their jobs. I didn't really realize they were officers until I was like being voltage shocked. The female officer, I forget their names. I'm terrible with names. She especially was very kind after the fact. The male officer, I don't wish him any harm. He seemed to be getting a bit angry at me. And that was a bit frustrating, but I don't want to hurt him.
I have no further questions at this time.
Wonderful. Cross-examine.
May I approach the lectern, Your Honor?
Yes. Listen, just for everybody can be approaching the lectern when it is their turn to be questioning. I just didn't do it before telling you because I thought it was fun for you to be asking, but now it is less fun. So you can just be approaching.
Thank you, Your Honor.
You are welcome.
Mr. Whip, I think it's a pretty simple question. Did you do the things that you're being accused of doing?
I performed certain actions, but I'm accused of, the charges levied against me have like
I'm sorry, Mr. Whip, it was a yes/no
things.
question.
I don't know how to answer then. I testified to what
Objection, Your
actions I
Honor.
did.
I believe this is an attempt to circumvent my client's Fifth Amendment right to not self-incriminate.
Your Honor, rebuttal.
Yes, you can have the rebuttal.
The defendant waived his rights to anything regarding the Fifth Amendment when he took the stand in his own defense.
Do you have response, defense? There's probably a different objection.
I am so sorry about that. No, it was worth a shot.
Okay, that is wonderful. You may continue, State.
Can you
I repeat the question for you if you'd like.
when you repeat it, can you specifically
I
read
will not
what I'm being
re-ask.
accused of?
Yes, I can read what you are being accused of having done.
Okay, thank you.
Did you do the things you are being accused of having done on the day in question? Aggravated. The charges you're being faced with are aggravated battery and aggravated destruction of property. Did you destroy property on the day in question?
I don't believe so.
Did you batter the officer on the day in question?
What is battery?
Give me a moment to look it up, and I can read you the legal definition of battery in the state of San Andreas.
It is the intentional, unpermitted act of causing harm or offensive contact with another, which includes hitting on a person or spitting on them. It becomes a felony if aggravating circumstances are met, meaning a dangerous weapon or the person on duty enforcement officer.
Or a government official.
That one.
I did not do that. Any contact was unintentional.
You can get to it.
Did you have permission from the courts to be on site power washing and changing and fertilizing the plants with the charcoal you had on you?
Objection, Your Honor. That's out of scope. I did not ask about the plants, but also he is not here for trespassing, so permission to be on the property is not the question.
Rebuttal.
Your Honor, the state's argument is he was on the property to beautify it and make recompense for what he had done prior in his bail hearing. It stands to reason that he would have reached out to the courts to get permission to be there and make his modifications to the courthouse.
Rebuttal. Question mark.
Unless the court is looking to retroactively apply charges not made known, again, the permission has no relevance. He's not being
I agree.
Charged with trespassing.
The court. Objection sustained. I mean, overruled. My bad. That is the one.
I understood what you meant, Your Honor.
Okay, perfect. Different question. For the record, they will sustain. That is the one I was looking for.
I was going to ask for clarification.
It has been clarified. Whoopsie.
It is fine. It has been a long day.
Apologies, Your Honor. I'm trying to make sure I don't forget to ask anything that. Your Honor, the state has no further questions at this time.
Wonderful. Redirect.
No further questions from the defense for the witness.
Wonderful, Mr. Whip. You are not free to go, but you are free to go back to your table.
Thank you.
You are welcome. Defense, any other witness or evidence to be presenting?
None at this time, Your Honor.
Wonderful. Closing statements, question mark. Do you need the time?
Your Honor, could the state have about 10 to 15 minutes to just make adjustments to their closing?
Defense?
I will gladly move forward with a slight recess.
Wonderful. 12 minutes recess.
Thank you, Your Honor.
All rise. Court is now in recess.
Oh my god, thank you.
You may be seated.
Oh my god, what was that?
I had so many questions.
What are your questions?
I have so many questions about this court case.
I am going to be honest with you. Up until she called him to the stand and he affirmed to be having the pressure washer, the exhibit D does not demonstrate any pressure washer on his person. How could he be spraying with the pressure washer if there is no evidence of the pressure washer? I mean, I guess the officers did say
I mean, but
was pressure washer.
I'm not going to say anything so it doesn't influence your thoughts.
No, I love to hear.
I'm going to be honest with you. Everything I heard so far, I would find him not guilty on no charges, even the lesser included one.
Even the lesser included?
I don't see how he. I don't. Well, oh, sorry. The lesser included was vandalism. You said?
Yes.
Oh, maybe I find him guilty on vandalism, sure, but not guilty on the aggravated battery and destruction. Because the officer testified that he did not sustain any injuries.
Yes. The charge of aggravated battery does not require you to sustain injuries.
Does it not? I thought it does specify that.
No. It includes
Causing
harmful or offensive contact.
He said, and he testified that he was spraying upwards.
There's the intentional part that is important for that charge.
Yes.
I don't know that I heard in a testimony that it was intentional. He intentionally spraying the water in that direction. It cannot be vandalism because there is not malicious intent.
Wait. So defense claimed 100% it's not self-defense, but also testified he sprayed the cop. Is that intentional?
He basically during the questioning, he intentionally sprayed in the direction of the person that he did not know is the officer. So he did spray the water intentionally in the direction of the officer. The water made the offensive contact. I'll say that would be guilty.
But okay, when that happened was because also testified to he didn't hear or know that officer showed up. So when you were spraying it, did he like when he got scared or something and turned and before he let go of the spray, could it have sprayed at him at that time maybe? But it's not but it's not self defense.
No, I cannot claim self-defense.
Okay.
There will be an affirmative defense, and they are not having affirmative defense.
Yeah. Alright, I'm gonna go back out there because I have to meditate.
It cannot be vandalism because there was no malicious intent. There could have been more prep. I don't know what is happening out there. do you think of this court?
They also just asked me the same thing, Your Honor. I don't know. Half of the time I may be here, but half of the time I may also not be listening.
Oh my goodness. What do I need to do? Ah. Let me look at this evidence right quick. I guess I should look at. Why are these not loading? Oh. Is there a charge that would have been more appropriate? I don't know. They probably could have proven destruction of property, but they present no evidence in regards to the actual damages. They could have seeked out something. They could have did more work other than just what they did. They need to think more thoroughly about the court. Think about the charges. What do I need to prove? Amount of damage. Oh, I think it is time.
Nah, Your Honor.
Oh, let us go.
All rise. Court is now back in session.
Yeah, court time. Okay, I did remember my pen and paper. Closing statement. State. You can be proceeding.
Okay. I'm going to see if I made the right amount of adjustments to my statement. Okay, Your Honor. You heard testimony today from officers and the defendant himself. During testimony, you heard what was found on scene when officers got to the courthouse and the events that soon thereafter happened, or that happened soon thereafter. You heard testimony from the officers that the defendant did attempt to, even if in the defendant's own words, was not intended to hit the officers with the water from the power washer. However, the charge of aggravated battery doesn't require intent. While the defendant didn't mean to spray these officers with water and didn't mean to do that in an effort to escape custody, he still did it, and it is still a thing that happened. You heard the defendant on the stand admit to coming to the courthouse with the intention to make modifications and changes to the aesthetic there, trying to fix it up and make amends for something that happened prior to during a bail hearing. It stands to argue that the defendant's actions of using charcoal to attempt to fertilize flowers may or may not have caused damage to those flower beds and quite possibly had led to them needing to be replaced. It is also it also stands to reason that in bleaching and trying to clean the outside caused further damage to the courthouse facade that again required time and effort from the Department of Public Works, from members of the judiciary potentially, to oversee and ensure that these things are taken care of and remedied. At the end of the day, you heard the defendant admit to doing the things that he did in his own testimony. While they might not have outright had said, I destructed this property, or they might not have said that I battered this officer, the facts are what the facts are. Even if the intentions were pure, there are still consequences for actions. The defendant was found on property, power washing the inside of a building, all the walls, that water was getting everywhere, and it stands to reason that that destroyed more than just the walls, the paint, the wallpaper, the carpets. That potentially does lead to more things needing to be replaced at the state's expense. Carpets, wallpaper, electronics. There are a multitude of things that needed remedy after the defendant's actions. And with that, and with the defendant's own testimony, the state asks that you find the defendant guilty of the charges before the court. The state has nothing further, Your Honor.
Wonderful. Defense floor is being yours.
Thank you, Your Honor. We are here today because of a chaotic, albeit bizarre situation that has led to felony charges being attempted to be pressed. The state carries the burden to prove every element of these felony charges beyond a reasonable doubt. When you look at the actual laws attempting to be applied, they don't quite fit. When it comes to destruction of property, the law is very clear that it must be proved that it was intentional, targeted, and a major or total loss. When we look at the evidence that was shown, we see photos of wet courthouse podiums, water on the floor, charcoal in plants, bleach on tiles. It was stated during officers' testimony that PW was asked to come and clean up, or that they did come and clean up or fix anything that was potentially damaged. But we saw nobody from PW who was brought in as witness to attest to any of said damage or total losses. We were shown pictures of water from a pressure washer. Water dries. Calling a wet service major or total destruction is a tiny bit of a stretch. On top of that, there is no proof of a deliberate, targeted plan to ruin government property. This was chaotic, erratic behavior, not a planned demolition by my client. Without proof of major or total damages, this isn't that isn't assumed possible damage or future damage. You simply cannot find him guilty of this felony. He was simply trying to correct a mistake he had made earlier in the day. As for the aggravated battery charge, the law does in fact state that battery is an intentional, unpermitted act causing harmful or offensive contact with another. He wasn't trying to intentionally hurt the officers. At first he was surprised, and then for all intents and purposes, he was trying to get space to flee, not cause physical harm. Nobody's saying that Chase's behavior that day wasn't disorderly, but today isn't to decide if his actions were strange or odd. It's to decide if the state proved the specific felony charges they chose to file. The law states that if the state does not prove its case, you must acquit of charges. Because the evidence falls short of the legal definitions, we ask that you return a verdict of not guilty on both counts. That is all.
Wonderful. The court going to deliberate. I will be back eventually. Don't go anywhere, or if you do, we'll proceed without you if you're not back. Get some snackies and drinks.
All rise, court is now at recess. You can sit down now.
Oh shit, I always forget to tell people to see it. Whoopsie.
Every judge forgets that, don't worry.
My bad. Let me see, lots of great points. Let me look at this specific charge one more time. Intentional, targeted, and willful destruction. Yes, he intended to be there. He targeted the courthouse for a reason. But I would agree with defense that there was no measure of actual damage. State many times said possible, could potentially, could result. The witnesses say, yes, many computers there could be damaged, but no evidence, no assertion if anything was actually damaged or completely destroyed. I would say that that would have been very easy to petition perhaps a member of the judiciary or public works to determine the actual amount of damages, but there is no evidence or testimony for that. I cannot find guilty of aggravated destruction of property. Lesser included offense of vandalism. I cannot find guilty of vandalism because there was no malicious intent. Hmm.
Mr. DOC person, I don't know your name. I'm sorry. I feel very rude right now. Yeah, sorry, Logan. That is name. I didn't know your name. I apologize.
Oh no, you're all good.
Almost done. How do I want to assert this for the ruling? Um,
Yeah, we got that.
Almost done. Um. Uh. Where did you go, notes? Almost done. What is this?
Welcome aboard.
What? What is that? Oh. Perfect. I was very confused.
Did you say something, Sunny?
Can you hear me? No, I did not speak.
Okay, I was just hearing things, I guess.
Um. Okay, I am done. Oh no.
Yeah.
Oh, he's on the phone.
Thanks. Alright, you ready, Your Honor?
I mean, you can finish your phone call.
Okay. Rain, I'll get this court case done and then I will call you back. Alright, bye-bye. All rise. Court is now back in session.
I am not going to forget this time to let you be seated. You can be sitting. Let me see. The court today thanking all parties for their presence and preparedness for this matter today. The court is asserting all parties they present the many good arguments for the consideration of the court. I will begin with some undisputed facts. The officers, Bishop and his I keep forgetting, responded to the courthouse 311 calls. Dispatch calls. The officers at the courthouse did find defendant chest sweep at the courthouse. The officers also find and document some damaged property, including the discolored tile, the charcoal in the plants, the water in the courthouse, and the shrubbery that did appear to have received the haircut from the blindfolded groundskeeper. Defendant whip wear the ear protection and have the loud water machine. Not here, the officers. The defendant whip spraying the water pressure at the officer, and whoopsie, and defendant whip debit taser at the scene and bring into the custody. That is just a quick summary. Let me see. In regards to the charges, we will begin first with destruction of property, 1 count aggravated. The court today is a start. Defendant chest sweep, as indicated during testimony by himself and witnesses, did be at the courthouse location and is being responsible for damage to the railings. There was glue, the tiles, there was bleach, water damage within the court building, the plants, shrubbery, etc. All in the pictures. However, the state not present any evidence or assert that any property did be being destroyed or did have the major damage. Although the testimony did be referenced the possible damage, the state did not provide any evidence or testimony demonstrate any specific value of damage, any repair cost, any estimates, or again testimony regarding the extent of any damage. And accordingly, this court cannot be adjudicate guilt on the possibility. We are required the facts. And the defendant is therefore not guilty of the charge of destruction of property aggravated circumstance. The court did also consider the lesser included charge of vandalism. Again, defendant Mr. Whip, as again indicated during his own testimony and by the witness, is intentionally at the courthouse and is intentionally causing the altering of the courthouse property. However, the offense of vandalism is required the malicious intent. No malicious intent today asserted during any testimony. Instead, defendant asserting himself the purpose was to clean and I don't remember the specific wording, but to make beautiful. Regardless of authorization or the improperly performed work, the state not proved that the defendant to be acting with any malice. Therefore, the court not guilty of vandalism. The court not going to consider the lesser offense of battery does not make sense. Anyway, the battery aggravated charge. Defendant Cheswip admit during his own testimony that he sprayed the water in the direction of the armed individual for the purpose to be distracting, so to be getting away. That individual did be his grant, the on-duty law enforcement officer acting within the performance of his official duties. Defendant assert the lack of knowledge regarding the officer occupation, but that is not negate the offense. The intentional act was the spraying of the water in the direction of the officer, and that spraying resulted in the unpermitted and offensive contact. The state is not required to prove the defendant intended to cause any physical injury. The intentional spraying in the direction or spraying of another person can be constitute the offensive contact similar to the nature of spitting. The defendant intentionally directing the spray toward the officer Grant, and the offensive contact did occur at that time, and Grant's status as the on-duty law enforcement officer is establishing the aggravated circumstance, and therefore this court is find the defendant guilty of aggravated battery. That is all. Sentencing recommendations.
Your Honor, in regards to the 1 times aggravated battery, the state recommends the time of 45 months and fine of $2,000.
Defense?
The defense would ask for some level of time served due to him being held until trial from the 1st through approximately the 16th, somewhere in that ballpark. As for the fine, I'm not going to ask for leniency on the fine.
Rebuttal state?
Your Honor, the reason for the defendant's incarceration in regards to this case was he breached bail on a previous case, and that should hold no bearing on his time in relation to the charges at hand. He has not served the time for, apologies. It just shouldn't have any bearing on that.
If I may, Your Honor, from what I understand, he was offered bail for these. His bail was not revoked for the prior bail. He just could not afford bail for these charges. If I am misunderstanding that, or if he was told incorrectly.
One more time, you are saying he was offered bail in relation to this incident and his bail did not be being revoked?
From my understanding, this was a secondary. He was offered bail for these charges, but could not afford the bail. Unless there is something that I am missing from
I
what
was
happened.
there. I know what happened. Clarification from the state, can you?
If you could give me a moment to confer with Officer Grant, as he was present for the arrest and everything.
Mr. Darwish, are you familiar?
Yes, I was the presiding judge on that bail hearing. We offered him 12,000 something, but he couldn't afford it, so he went for the nines. Then the secondary hearing after his court case, his first court case, when he got after it concluded, he went on bail. After that, I believe it was like $4,000. I believe I have to double check his docket. You have to check his docket to see how much it was.
Okay, so there was no violation of bail? My question is, why was he in prison for that amount of time?
There was no violation of bail. Because he couldn't afford, because when he was arrested again for this incident, he couldn't afford bail because we offered it $12,000, 12,000 something fine. He couldn't afford it, so he went for the nines.
Why was bail $12,000?
Because of the severity of the crime at hand.
Okay. So he definitely violated bail. State?
Your Honor, I am being told at the time of his arrest, there was a bail hearing that he, I believe, was told that he did not have the funds to pay at that time. The defendant was then sent in for the nines. I'm unsure of if that was due to him not being able to pay or his breach of his previous bail prior to that incident. The defendant was given time served for his previous charges, where he was then given a new bail hearing in relation to this case. I believe Chief Justice Clarkson sat over that.
That is correct. She did sit over that.
I myself wasn't present for either of the two bail hearings, so I cannot speak to that beyond what I just told the court.
The same situation for me. I was not present for either.
Me neither. Are you maintaining the full-time, full fine state?
Yes, Your Honor, I will maintain full-time, full fine, but will obviously defer to your judgment on this.
Of course you will. You have no choice. He did sit in prison for a very long time. Honestly, I'd just like to summarize. Mr. Whip defendant was on bail for different incident. He break the bail for that incident, get another bail hearing, and could not afford the subsequent bail and went to prison for a long time. Yes?
Several days, Your Honor.
Mr. Whip, did you enjoy the prison?
Parts of it less so. Like a lot of things in life, it's a mixed bag. I learned.
What did you learn?
That his call sign is C4.
Is this correct, Mr. Logan?
That is correct, yes, Your Honor. My call sign is C4.
I like that. I didn't know that. I feel like I have learned something.
I didn't know that as well, Your Honor. That's new information.
Thank you, Mr. Whip, for
we all learned something.
Thank you for your education.
Yes, thank you for your education today. The court. The court today, I am going to give the time served with the $2,000 fine. Mr. Whip, please, when you are on the bail, no more violation of the bail. I appreciate you not violate this bail. Wonderful. So you have learned that too. $2,000, 0 months. Please, you are not supposed to enjoy the prison, okay?
Well, I didn't enjoy all of it.
No more talking. I mean, you can't talk now. Court is over.
Thank you, Your Honor. Hey, Your Honor, would you be so kind as to sing your song for opposing counsel since they missed it earlier?
What?
Oh my god, opposing counsel, would you like to hear this song?
Absolutely. Absolutely.
If you don't want to hear this song, I guess you better hope somebody unlocking the doors.
Otherwise, you're stuck here and forced to listen anyway.
That is correct. This song is called the Prostituter Song. And it go a little something like... Listen, I used to be the step prostituter. It go a little something like this. Dash it through the court when it gets doing today. Or this time they go questioning all the way. The defense they will object, but I will stand my ground. I prove the defendant's guilt with evidence abound. Jingle bell, just as well, let's put crooks away. Oh, what fun it is to fight crime in court today. Jingle bell, jail cell, the court will make them pay. Oh, what fun it is to put the crimes away. Review the documents and reviews and the reports. Build a solid case against the crooks of sorts. Organize exhibit and questions with take care. Cross-examine witness that's in the witness chair. Make my closing statement. Lay out all the facts. Evidence be on my side. I know just how to act. When it's time for verdict, the court, they will see. Defendant must be guilty. Judge Darwish, he will agree. Jingle bell, just as well, let's put crooks away. Oh, what fun it is to fight crime in court today. Jingle bell, jail cell, the court will make them pay. Oh, what fun it is to put the crimes away. This job is beyond stressful, I swear for what is right. Upholding of the laws and keeping up the fight. The hours they are long, but I will persevere. Lady Justice she do call, so crooks should live in fear. Just kidding, it will be being the default judgment case to miss, violate the bail, witness not showing up. I changed my plea to guilty. This song is bullshit.
Did you mention bleed? Did you mention the plea deal?
This has been
No.
a wonderful court
You
case.
should have
That
bleed.
is
You
all
should have
I'm
bleed
going to
in
say.
there.
Do any parties have any questions about anything that you wish to ask it after the court hearing?
What meter is that song in?
It sounded
4-4.
4-8.
I do have a question, but it's more for Logan.
Huh?
Logan, when are you gonna become Charlie 2?
I don't know.
That's
Are
fair.
any of the officers still around?
The door is unlocked if you need to leave.
Okay. Well, I asked because he.
I do need somebody to probably give him his fine.
I'm in the process of doing a Your Honor.
Oh, could I have left without the fine if I chose?
No, that would be very bad, Mr. Whip. But
Both of
consider
us.
having to listen to that song part of your sentencing.
You know what? I wouldn't consider that sentencing. That was fantastic.
Yeah, that was the part
Oh my
of
God,
the
thank
prison
you.
enjoyed,
Oh my God.
Mr. Whip.
Are you okay?
Yeah, are you okay? Do you need staffer?
I will go see the hospital after this.
I have bandages. Would you like one?
No, I have to see the hospital. But you don't have to go to help with this.
Sure. Would you like me to drive you to the hospital?
No, I walk.
Okay.
I have duct tape and a toolkit and water and cement. I
Your
could
Honor, how
cement up
much
your
was it?
injury.
2,000.
Did you use duct tape to
2,000,
cover your
okay,
broken
thank
leg?
No, I went to the hospital.
Can you please maybe keep your tools and water away from the court?
Why are you
Alright, I need
taking
to
my
run
car?
on.
Yeah, I'm still trespassed
I
from the
need to
back.
go. Get
Okay, I gotta go.
his,
Bye.
Bye.
I need to get his.
Oh my God. Oh my God.
I think I'm still trespassed from the back. Is that over?
I forgot to tell the officers that any further. Dang it. I'm sure they are fine. They will figure it out.
Clarification, Just Whip, you are still trespass, yes.
Is that permanent?
Yes. The
Okay.
Chief Justice until the Chief Justice Willow lifts it.
I will
thought
get
so, I
the.
just
I just going to let you know that I'm going to get the public works to put up a sign specifically they say no chest sweep at the back of the
Okay.
court.
Hold on, should we put it? No, should we take a photo of him and put it up on the wall?
Oh my god, yes.
Mr. Whip, you have been fined.
Oopsie. Wait, let me do it my phone. Yeah, that's better.
Oh, but you allow them to take your pictures, but you wouldn't allow me to take your picture.
Well, to be fair, you are C4.
You were trying to like accuse me of a fire, right?
No, someone's already been charged for it.
Why did you want my picture?
Because I was just following you around with the camera.
I'd like to stalk.
That sound like.
You were in the prison. I had to make sure you were okay.
Okay.
For what purpose was the camera?
There's no purpose to me following you with this compared to me following you with the cameras mounted to the wall.
If you say so. I don't tunnel into the prison. I don't know what's down there.
Wait, you're gonna tunnel under the prison?
No.
Ah. Please don't tunnel under the prison.
I'm gonna give you your items that I stored back.
Thank you.
You know, my favorite objection
your
was
absurd amount of gas
the
cans.
objection from
Yeah,
the
because we
defense
heard something to do with
that
that.
should the state try to make him incriminate himself.
Mr. Whip,
Sir,
put it away.
Mr. Whip,
Put this away.
get out of my court with that mess. I strongly encourage you to run from the court.
Again.
Move faster, hobble faster.
I appreciate your time, Your Honor.
You come back.
She said, Your Honor, objection. They are trying to make him violate his right to self-incrimination, not doing it on the station. He give up that right when he take a stand.
Yeah.
She had no rebuttal to that. I said, yeah, that's what I thought. Whoopsie.
It's okay.
Yeah, I always log in.
That was pretty funny. What did you think of my ruling?
I agreed with the destruction of property one. The aggravated one, I would have to look a little more into that one, but I don't know.
Well, here's the thing, Mr. Darwish. It is very similar, in my opinion, to if somebody kidnapped me, not know I am the judge, it is still aggravated kidnapping, hostage taking.
No, the key word was the intentional part. Like, I don't think I
Yes,
don't know if they proved
but
intent there.
he assert himself that he intentionally spraying the water in the direction of the armed individual that he did later learn to be the law enforcement officer. That is the intent right there.
Oh, he admitted to. I didn't hear that part. Okay, that's why I
Yes.
said I had to. That's why I said I had to look into it a little bit because I may have missed some things that I didn't hear. I mean, okay, then
He
I would
assert
agree with you
himself
then.
that he's spraying up there. Yes, the first time he turned around, forget to turn off, he's spraying. The officer even said, yes, it was unintentional. But then when he was up the stairs, he's spraying on purpose, intentionally in the direction of the officer.
Okay, I missed that part right there. So okay, there you go. Oh yeah, then no, okay, then I agree with your ruling then.
He did not be processed. The additional spray. The officer only see the gun. They was on the upper platform and he run towards the back. He's shooting it in the air. Try to be distract the officer and shoot the few times. So he is intentionally spraying that direction to be distract. When he intentionally spread that direction, he make a direct contact with the officer. That is my opinion. I feel like the state could have proved the destruction of property had they done any further effort or investigating. to be getting any sort of evidence of the actual damages. The code of conduct judiciary, a little bit more complex since the Chief Justice was preside, but code of conduct public works, maybe, I don't know. I have to put this on the docket. Greetings. My puppy, I need to let him out. Poor baby. That was fun. Do you want to go hang out at Elysian Squares to see if we can kidnap it?
No, it is way past my bedtime.
That is boring. I probably should also be sleeping. I have a meeting tomorrow. There's no officers on duty. No, this is a different kind of meeting.
No. I'm saying, are you happy that you had the court case?
Oh my god, I did love court. Did you like how I made them request to approach it the lectern every time until I got tired of hearing them request permission?
yes.
That was fun. Did you like my comment about the blindfolded groundskeeper? I did have a little bit more to add, that the groundskeeper blindfolded was armed with the hedge trimmers and the personal grudge.
I'm going to be honest, I probably missed that part.
Why you not listen to my court?
Sometimes I either go, like, I think about bathroom, or I think about eating the food.
There's about to be aggravated battery somewhere on this property.
Oh my god, is it chest swap again?
Oh god, I hope not.
It's crazy.
He's not allowed here. Oh my god, I look so cute.
Are you
I
going
should
to
wear
the
more
gym?
ascot. No, I am going to sleep. I don't know why I'm going there. I'm going to
you going to-
sleeping. You know what?
Good night.
I'm going to sleep.
Don't sleep in cell 4, okay?
No, I sleep in a witness chair. That way, when I am waking up in the middle of court proceeding, it is the most amount of awkward.
No, mine's right here. Mine's standing right here. I sleep right here.
Oh. I'm sleeping right here.
Right behind the witness, be like, booga booga.
Yeah, I can be like, surprise. Good night. Let's see if anybody streaming to be raiding. I don't know where's the officers tonight, but I have to take care of my puppy. He just had this operation today, and I'm going to take him for a walk. Nobody to be ready. Thank you for coming to court. Interesting as always. Listen, Mr. Serba, it has come to my attention, and I am deciding what to do. But listen, there happens to be a civil docket with your name on it, where there was a plea agreement that has a confidentiality clause, and you did subsequently post the agreement upon the docket to the public. I will see what this state does with that, but I just thought that was funny. Anyway, good luck to you, and good night.